Yeah, hi everyone. I'm really sorry for the delay. So I'm good to start at any time that the organizers are fine with. Thank you.
Yes, sir. Good afternoon. A very warm welcome to the esteemed dignitary and to all the participants. Thank you for joining us this afternoon. Before we commence this session, I would like to give a brief information about the collaborating partners. This first virtual moot court competition is presented to you by Vadodara DLSA in collaboration with Sambhav Initiative. Legal Services Authority is a statutory body and has been constituted under the Legal Services Authorities Act 1987 with the motto Access to Justice for All, providing free legal aid, advice, and services to eligible persons. It promotes the spirit of amicable resolution of disputes by organizing local adalats and through other forms such as mediation and conciliation. It also spreads legal literacy and awareness among the masses. Sambhav Initiative is a pan-India initiative that is aimed to promote, facilitate, and encourage the people to utilize various methods of alternative dispute resolution. It provides for free legal aid services, works towards shattering mental health taboos, and endeavors to achieve Goal 16 of Social Sustainable Development Goals, which is peace, justice, and strong institutions, with the mission of reach out, rapport, and rescue. Sambhav Initiative firmly believes that education is the mightiest weapon that can be used to change the shape of the nation. Therefore, it educates, enlightens, and equips the people with the tool of knowledge. It aims to become the voice of the vulnerable, unseen, or unheard. Now, I would like to give a brief introduction about our esteemed speaker and trainer of today's session, Mr. Sonak Rajguru. Mr. Sonak is an associate at J. Sagar Associates and Solicitors, New Delhi. He has advised and coached multiple teams for national and international moots like NALSAR's first public international law moot, Stetson International Environmental Law Moot, Jessup's International Law Moot, ICC Moot, FDI Moot, NUAL's Trial Advocacy Competition, and NLIU Corporate Law Moot. He has conducted various moot court workshops at Maharashtra National Law University, Lloyd Law College, Utkal University, Bhubaneswar, KIIT Law School. In his student life, Mr. Sonak won laurels in various moot competitions. Like at 33rd Bar Council of India Moot Court Competition, he was a part of the winning team and was also the best male advocate. He was the best speaker in round 3 and had the best written submission. He has also won the Winners and Best Advocate Award at 3rd IIT Law School National Moot Court Competition, Winners and Best Advocate Award at 6th FYLC Ranka National Moot Court Competition. He was the best advocate and reached the semi-finals at 7th MS Ramaiah Memorial National Moot Court Competition, Bangalore, and the quarterfinals at 23rd Stetson International Environmental Law School. We will reserve the last 5 minutes for the question and answer session. Participants can type their questions in the chat box. Now, I would like to yield the floor to our dignitary. Over to you, sir.
Thank you so much, Devanshi, for having me over here and also for your kind words and introduction. And also many congratulations for you in order to organize something like this, especially for the students across Vadodara. And it's very a niche initiative, I would say, and it's very, kind of also very encouraging to see that, small scale events like this will do wonders and prepare them for even bigger national moots. And I think organizing a training session before the moot is also a very good idea. And I really appreciate the entire effort that you all are doing. But before I commence with this session, I would like to indicate that today I don't want really to be a kind of a lecturer here in order to give you all forms of tips and advices for mooting. But what I would really want is if this can be more interactive and more question and answer oriented. So instead of last 5 minutes, I would rather insist if it can be at least 15-20 minutes of Q&A, because I think the purpose of a training session would be achieved if all the queries or all the kind of preliminary issues that are in the mind of the students get addressed. But before that, what I suggest is I'll go on for about 25-30 minutes of indicating what are the very basic elements of mooting, starting from day one and till your oral submissions and your, till your day end, as in the day you have to win your finals. I think what it takes in the entire journey, and why I call this as a journey is because it's an effort of a team right from day zero, from your when the proposition is released till the time you have to put together your research. You need to do everything possible in order to make out a good case for yourself from both the sides, and ultimately present it before a virtual court, I would say. And I think therefore I just take 30 minutes or 35 minutes in order to cover the basic aspects, because with the time being short, I don't think we can go much into details of each and every element. Although preferably I would have loved had it been a workshop of about 4 or 5 hours with adequate breaks, so that every one of you could have got a thorough idea as to what each element in the mooting requires, and what is that thing that you need to keep in mind before going into your next national moot. But in any case, I think I'll try my best to cover most of it in 30 minutes and leave the last 20-25 minutes for Q&A. And if permissible by the host, you all can also intervene me at any stage and ask me a question directly. I would love to answer that right away, because keeping the questions till the end may also mean that you may either forget what you really wanted to ask. Also, it may become out of context for some. So if you think that your query is relevant enough for about what I am currently speaking, then do intervene at any stage. I give you that freedom, and ask me a question right away, and I'll try my best to answer that or address that. So I think unless there are any very preliminary questions, I would just start right away, and I'll stop appropriately as and when Devanshi, you get a question, please do stop me, and you can also intervene and ask the question on behalf of all the students. So I think we can also go by that approach. So without further ado, let me start with the very basic aspects. I think what you need to keep in mind right away is, although all of you, I believe, are the participants who are going to participate in this national moot organized by Sambhav and by VDLSA. But what I'm also going to deal in entirety is not just for this particular moot, but for your future moots as well, as to what should be the approach and how you need to proceed. So the first thing is, I think it's about forming the team. Forming the right team is very important. What you need to keep in mind is moots are ideally about a team of 3 or 5, and you need to make sure that you have a very good combination of 2 good speakers and 1 researcher. Now what happens with that is, either you sometimes go for all 3 good speakers and you think that one of them will compromise the position and go for a researcher, or rather the best idea is that you find someone who is very effective with research, who may not really be wanting to become a speaker, and then go for 2 straightforward speakers in the team, because that would avoid the conflict. That would also avoid some internal conflict within the team at the stage of the ultimate moot rounds, or when you are registering for the moot as speakers or researchers. To avoid all forms of internal conflict, I would suggest you to go with a clear team, so that there should not be an issue. And why I'm focusing on this team aspect and the internal conflicts is because it's a long journey. It may be a journey of about 6-7 months for some moot, where you need to start from the scratch, research, and then participate in the moot. And therefore, until unless you have a good team, until unless you have that coordination within yourselves, until unless you have the understanding and teamwork within yourselves, I don't think you'll be able to survive those 6-7 months. And not surviving those 6-7 months means, one, waste of your time, and second, at the same time, you may have to withdraw at the last moment from the moot. That gives a negative impression about your college as well. Therefore, you need to keep in mind that when you are going for your team, you should have a common goal, a common intention to win the moot. At the same time, make sure that whichever subject area that you're choosing is of common interest to all the team members. Because what would happen is, if you, for example, individually are a constitutional law enthusiast, and on the same time you have someone who is interested in criminal law, and the other guy is someone who is interested in competition. Now, with that, you have a team which is not having a common goal of understanding the nuances of a particular field of law. Then, if you choose a moot in constitutional law, I'm not sure whether the other two, that is the criminal law enthusiast and the competition law enthusiast, would be giving the hard work and their efforts in the same way that you do as a constitutional law enthusiast. And therefore, it's very, very important to have a team which would really inclined to learn the law in the same spirit as other members of the team. And that is what will give you a good team. And lastly, I would say just don't go by your personal relationship. Maybe you have a friend, but don't see a mooting teammate in that friend. I'm not saying that friends and all won't be good teammates, but all that I'm saying is if you are going for a team, you need to maintain some professional relationship throughout the period. There may be times where you have to confront the other for not working the hours that they should put in. And you should be comfortable enough in order to do that. If there is a friend or someone very close, then you may not be in that position in order to confront that, and that may affect the team morale as well. So, few basic things about the team that you need to keep in mind right at the beginning of the moot before you even choose your. So, the second thing that follows team formation is choosing the correct moot. Now, here choosing the correct moot, what that would mean is not just don't go by the name of the college. Just don't go by, oh, how big the college is, what implication it would have on my CV if I participate in the moot hosted by that college. Nothing of that matters. What you rather should see is which is that particular area of law that you are really interested in, and what is the college that organizes the best possible moot in that area of law. I don't want to take name of colleges, but what I'm only trying to say is, say there is a constitutional law moot. You want to go for a constitutional law moot. Now find out which is the college which organizes the best constitutional moot in the country. And all of that details you would get at multiple websites these days, Loctopus, SEC Online, all of that cover the details of all the moots. And the past years, 4 or 5 years of proposition would give you an idea as to which area of law does the moot emphasize on. And based on that, you can select or map your moots. And after that, you can always insist your college authorities to allow you to participate in that moot, and also give enough reasons to them as to why you would like to participate in that moot, so that they also facilitate the entire exercise. And that is how you need to choose your moot. Just don't go by the name of the colleges. Oh, XYZ college is the best college of India, I would like to participate in that moot. That does not help you. What if that college does not even deal with the area of law that you're interested in? And that is where you would lose interest. You may not really be inclined to do that, in comparison to what efforts you would have put in had it been your choice of law. And therefore, choice of law and the area of interest is the most important thing that you need to keep in mind while choosing the moot. That is the second step. Now, the third step in any mooting process is going for your proposition. Now, once your proposition is out, you need to do two things. One is figure out what are the undisputed facts in the matter. And secondly, figure out what are the disputed facts in the matter. Now, undisputed facts may be certain facts, figures, data, or anything that you cannot contest, anything that is accepted by both the parties, and no one is contesting becomes obviously an uncontested or undisputed fact. Now, undisputed facts may not be that relevant for formation of issues, but they may be very, very critical when it comes down to joining dots between arguments. But let me now come straight away to disputed facts. Now, what are these disputed facts? Disputed facts are, by the name suggests, it is something that both the parties are contesting. Now, I'll give you a short example and make you understand what may be disputed facts from that event and what may be undisputed facts from that event. Now, imagine a husband and wife were last seen in their bedroom on the last night, and there was a watchman in the house. On the next morning, the wife is found dead in a pool of blood. Now, in that situation, the question arises, who has killed the wife? The husband was last seen. One probability is that the husband would have killed the wife. The other probability is that the watchman would have killed the wife, being within the same house. And the third probability is someone else would have entered the house, broke into it, and killed the wife while everyone else was asleep. Now, these three being probabilities, The question of fact as to who killed the wife is a disputed fact. No one is agreeing over one context or one element of fact, and hence it's disputed. Whereas the fact that they were husband and wife is not disputed, so it goes as an undisputed fact. The fact that there was a husband in that house on that night is again an undisputed fact. And the third undisputed fact in this is that the wife was asleep. And the fourth undisputed fact is there was also a watchman present in that house. From a very short 2, 3 sentences, I could give you four undisputed facts and one or two disputed facts. That is what you need to do and churn out from the entire proposition. So then maybe your entire proposition would have 100 disputed facts and say 50 undisputed facts. Now, from these 100 disputed facts, you will have to go to your next step, that is creation of issues. Now, what is an issue at the end of the day when you'd be saying that I have to frame an issue? And how do I frame an issue? My suggestion always is your disputed facts would take you to your issues at hand. Now, what are issues at the end of the day? They are the contesting question of facts or the question of law that both the parties are basically going to put forth their submissions and establish. That means it's not accepted to either party. One party is saying in for, the other party is against that particular aspect, and therefore it becomes disputed. And you are getting the context of an issue from your disputed facts itself. So, who has killed the wife becomes an issue, and that issue is coming out of a undisputed fact regarding killing of the wife, right? And maybe there will be other issues like the murder weapon, like the chemical analysis of the weapon, like the post-mortem report, and various other several aspects. So therefore you need to keep your disputed facts into broader heads, take them into 5 broad heads, and those 5 broad heads convert them into an appropriate question, and that becomes your issue. It may be a question of fact, it may be a question of law. Make sure in what stages of trial or in what stages of courts, maybe if it's a constitutional law issue, you can't raise a question of fact in Supreme Court. If it's an SLP, you again can't raise a question of fact in Supreme Court. If it's a civil appeal, a second appeal, maybe you again can't raise question of facts. But in before high courts, before other courts, you can raise questions of fact alongside questions of law. And therefore, you need to keep that understanding in mind and have to gather that information as to before which forum are you in, where are you arguing, and what kinds of issues can you frame. And that is something you need to keep in mind while framing your questions. So in brief, I have captured the how to deal with your fact sheet or the proposition, how to frame issues at hand. Now, the next obvious thing is once your issues are ready, once you have a clear idea as to what area of law you're dealing with, the next obvious thing is the research. Now, for the research, I would propose a 3-step methodology. First would be go for the old school method. Go back to your commentaries, go back to the statute book, go back to the plain words of the law and interpret it right away. If you're not able to interpret, go to commentaries, understand their intent behind the interpretation, and then give effect to that statutory intent. And the only next thing or the second step should be go for the latest case laws. Now, latest versus old or landmark judgments would be the best idea to go ahead with. You should know at least 2 landmark judgments of an issue and 2 latest judgments of an issue, so that even if a judge asks as to why is the 1970 judgment relevant as on date, you then show them that see, even a 2020 judgment is also there, and that 2020 judgment says the very same thing, and or rather upholds the 1970 judgment or follows the 1970 judgment, whichever way it is. And therefore, your research credibility is well appreciated by the judge, that okay, it's not just that you have also read so many judgments of the past, you also have a hang of what is the latest position of law on the issue. And the third step of research I would suggest is go for that X factor in you. Now, please understand that when propositions are quite easy, sometimes it is the X factor that would, make you win over another team. Now, what is that X factor? You need to know something beyond the law. Now, beyond the law, why I say this is as a lawyer, we should not just confine ourselves to the text of the law. We also need to understand the societal values. We need to understand economy. We need to understand forensic science in a criminal law mode, for example. We need to understand the climate aspects if you're dealing with environmental law modes. And therefore, science or forensic science or ballistic expert study reports, there are a lot of things where your knowledge beyond the law would be tested in the courts of law. And therefore, that is where you as a lawyer need to assist the bench, because the bench may not be equipped. And therefore, it's the role of a lawyer to go beyond the law, beyond its comfort zone, and give that extra factor into the mood. And that is where you'd love and rather would see that you are doing very, very well in the mood, and you are easily going leaps and bounds over your quarters, semis, and finals. And I would give you an example here. In one of my moods, it was a criminal law mood. And the question was, will a 250 milligram of a particular composition, chemical composition, or a poison was enough in order to kill a deceased? Now, the answer was, very circumstantial. And at the end of the day, as a counsel for the accused or the defense, my submission was 250 was not enough, because that is not an appropriate portion of the poison which has the capacity to kill a person in general course. That means there has to be something more which would have killed the wife, right? And in that situation, the bench right away appreciated. I gave a lot of scientific reports to corroborate my submission. It's not just that it was on air, but I had done some proper scientific research on that aspect. I gave them really good publication based journals which supported my argument. And that is where the judges right away appreciated during in the middle of the rounds that this is something exceptional, and we knew that we are going to win the round right away. And that was a final of a very, very good national criminal law mode. And therefore, you never know where these kind of X factors can really help you. And therefore, my piece of advice would be that the third thing, beyond your statute books, beyond your commentaries, beyond your case laws, also go for that extra bit of research on other allied areas beyond the law that may be applicable to the facts of your case. And therefore, that is something you need to keep in mind. The next obvious thing is, after the research is done, it's memorial drafting. But my suggestion would be that memorial drafting is something that would take a session in itself. But just to quickly summarize few aspects, there is, you need to follow IRAC throughout. Now, IRAC is something which is called as issue, rule, rule A would be for all forms of analysis, and C stands for conclusion. I'm repeating it again. I stands for issue, R stands for rule, A stands for analysis, and C stands for conclusion. Now, here what happens is your entire structure, may it be issues, sub-issues, sub-sub-issues, should follow IRAC in themselves. So the ultimate draft also follows IRAC. Now, here what happens is, when you start, you give right away what the issue is that you're dealing with, so that everyone who reads understands the issue straight away. Then you go for the law, that is the rule. Rule would include all forms of statute, rules, applicable provisions, applicable law, etc. Then give the analysis, corroborate the rule to the facts of your case, correlate them, and try to establish that why the law applies to your facts. That is where you analyze the law. And then give a conclusion that in view of the above, this is my conclusion. So that is something you need to follow for each of your argument. Now, again, argument should be, as I mentioned, divided into issues, sub-issues, sub-sub-issues, and go for whatever number of sub-elements of issues you want. And that would give a clear sense of clarity to the evaluator as to what the student has covered in the particular memorial, or the team has covered in the memorial. So I think that is the approach you need to keep in mind. Be thorough with your jurisdictional aspects. Some moods may not really have an issue on jurisdiction, but still judges love to question you on jurisdiction, on your basic understanding of the forum that you're arguing before. And also be very specific with your prayer. Your prayer should not be a copy-paste element of your entire issue. It should rather be a strict, short prayer that you want from the court. Also understand whether the prayer that you're asking for can even be granted by the court. Now, for example, some courts have limitations on the amount that they can give as compensation. Now, if you are asking for a higher compensation, there are specific other courts for getting that relief. Now, without knowing that, if you have gone to a court where the relief cannot be granted, that means you are one, now not aware of the law. Second, you are wasting the time of your client as well. And therefore, that all these things do matter, because ultimately your prayer and jurisdiction are interrelated. If the court does not have the power to grant you relief, the court does not even have jurisdiction to deal with the prayer. And therefore, your prayer and jurisdiction should sync with each other. And that is the first thing you need to evaluate before choosing which forum are you going. Sometimes the prepositions remain silent on the forum, and that is where the students are left to research and analyze which should be the correct forum. Sometimes questions would be that why is it the High Court and why not a specialized tribunal which is constituted only to deal with a specific issue? For example, in electricity laws, there are specific tribunals, and the High Court should not be the forum where you should go with a dispute regarding the electricity sector. Similarly, there is NCLT, there is NCLAT, has effective aspects to deal with the questions of Companies Act. And therefore, you need to understand which forum should be the right place to go, whether if it's a consumer redressal forum or a high court or a specialized commission or a tribunal, or is it the Supreme Court? All of that is something to be well researched on from the given facts and circumstances. The last advice I would give you about your memorial is do not assume any fact. Now, what the proposition sets out, limit yourself, confine yourself to the facts mentioned therein, and do not exceed or do not expand your scope beyond that. I think these are the critical elements about your fact sheet, issue framing, research, and memorial drafting. Lastly, I would like to cover the oral advocacy aspects as to what one should focus on during your oral rounds and how you should present your case. I think what you need to keep in mind is number one, you should never ever read from your speech. Unfortunately, I've judged over 50 virtual moots now. Earlier that was not the practice during the physical moots, but in virtual moots, students have tend to devised a way or the other in order to read from the screen or maybe a paper on their side. And that is, you may think that we as judges do not take notice of it, but it's very evident from the eye movement that you have on your screen. And that is something you should avoid. uh, One, as a matter of your own understanding of the law should be good, and second, you should not deceive the judges, right? It's not a healthy practice to do that. Secondly, always maintain eye contact with the judges while arguing, because the moment you lose eye contact, the judge also loses interest in your arguments. And that is something I have learned over my experience of mooting, of having done about 18, 19 moots during my time, and also now during judging so many moots, that if you lose eye contact with the judges lose you. And that is the last thing you want, right? A judge is losing you, therefore not taking note of your arguments, and therefore may have missed very, very critical arguments that you may have. And then you would be pondering, oh, why you lost the round, right? And that is something you should avoid. Now, coming to the speech in itself, I think I'll just tell what I used to do as a mooter back then, because I believe speech is something that is subjective. I can't tell you that this is ABC way of drafting or having a speech in place. And I'll just tell you what I used to do. Therefore, whether if that's feasible for you, you can adopt it, or you may have your own way of going ahead with your speech. Now, what I used to do was, my first ever speech used to be a finals speech. The reason for that is, now prelims may give you just 10-15 minutes of arguments. Your quarters may give you about 20-25 minutes of arguments. Your semis may give you half an hour to 45 minutes. But finals would ideally give you 45 to 1 hour. And I have faced situations of being in the finals of at least 7-8 times, and I have to argue for over 2 hours sometimes, including in the BCI finals. I had argued for 2 hours 15 minutes. Therefore, what you need is content. You can't just go without content, knowledge of law, the research. And therefore, the bulky speech right away that I used to make at the first place was for my final round, assuming that I'll have to at least speak for over 1.5 hours. Now, once you have a detailed speech, it's very easy to cut down. And for then, I used to then have 4 sets of speeches: one for prelims, one for quarters, one for semis, and then the finals. Now, the benefit for that is when you are in your prelims, you know your final speech as well. That means you know a lot more than that which you are saying in your prelims rounds. So if a question is being asked, you have 4 different ways at least in order to answer that question. And that is something is a very, very beneficial thing for you, right? Because if you have 6 different judgments for your final rounds, while you have taken just one judgment for your prelims on a specific issue, then if a question comes and the judge is not very satisfied with that one judgment, you have 5 more judgments to cite. But if you just go ahead with your speech having one judgment for an issue, you're gone. And therefore, that kind of experience is something I can share with you that it used to be very, very helpful. The second thing that I used to do was I always refer to a compendium on the side. Now, what I mean by a compendium is it's a compilation of all the authorities of law that I was quoting. Now, for example, if I used to start my speech, and in my speech, there are, say, 30 judgments that I was citing, 5 research papers or journals of a very highly reputed scholars that I was citing, etc. So, say I was citing total 40 authorities. Now, then I used to take the printouts of those judgments or the research papers in a sequence the way they appeared in my speech. And I used to flag them and number them as 1 to 40. So I don't used to write them as Kesav Nanda Bharati in the flag paper, but I just used to write 1, 2, 3, 4, etc. And then I was cross-referring that in my speech. So wherever in my speech I used to extract the whole judgment, I used to write the name of the judge, the citation, the extract, and the entire para that I was quoting. And then I used to write 1 on the side. That means I know while preparing, while the whole preparation that goes into the speech, I now thoroughly know that okay, serial number 5 would mean Kesav Nanda Bharati, right? And that is when I could go to the rounds. I looked straight into the eyes of the judge because I was prepared my speech so much that I clearly used to cite judgments as if your lordship may refer to flag number 5 that deals with the judgment of Kesav Nanda Bharati delivered by this many judges, etc., etc. And that is how I used to refer my arguments while or refer to my compendium without even having a compendium on my side. Judges were kind of going berserk or astonished as to how I was able to refer to a 1,000-page document without even having that with me. But the secret was it was in my speech. Obviously, I was also not referring to my speech or reading from my speech, but because of the practice, the kind of practice you have to do for your oral rounds, you need to write your speech at least 50 times before you actually go for your rounds. And all of that practice obviously will result in a situation that you need not ultimately look at your speech at all while arguments. So I think these are some techniques I wanted to share with you, about your mooting aspects. And obviously the time was short. I could have gone into details of each of these elements. And I leave the floor open now for any forms of queries from what I said or from what you have. Obviously, I will not answer anything specific to the mood that you're participating in. Although I've not read the facts as well, I would request Devanshi to immediately prompt if a question directly falls, which would go into the merits of the mood that all of them are participating in. Because I believe the objective was just to train in general, not answer anything regarding the mood, because that may not be the scheme of things. So I leave the floor open. If you have any questions, you can directly intervene and ask, or leave the questions in the chat box so that we can cover for the next 10-15 minutes before we end the session.
Participants can unmute and ask their questions.
Yes. Also, Devanshi, you can let me know in case you receive any question only on your chat. I mean, they also may not be comfortable in sharing everything on the entire group.
Sure, sir.
So yes, guys, if you have any questions, come forward. You can choose to come on video or not. That's up to you. You can ask questions to me, and that may be anything pertaining to the book. Yeah, hi. Go ahead.
Yes, sir. So actually, currently I'm in my first year. Like I have joined college 15 days ago almost, and now that we have a moot court competition, I was kind of looking forward to it for with a motive of experience and understanding stuff. But currently, when I saw the mood problem, right, then I was wondering that how should I start, because I don't know most of the stuff. Like the problem that we have, the mood code problem. It is about divorce. It is containing criminal law elements and also women laws and divorce. So I was kind of confused that how should I, encounter this problem and how should I proceed and go ahead.
Right. Samriddhi, as I mentioned, I won't be able to answer anything specific on the proposition that you are dealing with for this particular mood. But let me just give you a general answer as to how to approach. Is one, you need to just read the facts well in advance, understand the facts of your matter, then just look for what may be the applicable laws, which is that where act or which is that act which would apply to you. Read the act, read the provisions, and then try to develop an argument, either applying or disapplying the provisions as to whether a provision would apply in your case. If you are on the other side, then show that why the provision would not apply to your case. I think that's the only way I can suggest right now to go away with it, because I can understand you may have just started with your law school days. Obviously the law may not be that clear to you, but that is how you need to approach. Read the facts, understand what law may apply, and then read the provisions. Try to understand the provisions to the best of your capabilities, and then apply the facts to the provisions. Whether the provisions apply or not apply is something a matter of arguments. I think that is the strategy you need to follow.
All right. Thank you so much, sir.
Thanks. Yes, Parul, go ahead.
So I'm confused about which forum to apply for. Like, should I go for family court or district court for domestic
I'm
violence
sorry.
cases?
I'm sorry, Parul. I think all these queries are coming straight on the facts that you're participating in. Devanshi, you can clarify whether I should be answering these queries, because uh, don't you think that this would clearly be detrimental to the other students as well who are
Right.
participating?
Right. Participants are requested to ask questions regarding how to prepare and perform in a
In
moot court
general, you
competition.
can go for general queries, because see, the moment I answer any of these, you try and understand, right? It's like helping you for your moot court competition, which may not be possible on my part right now.
Okay, sir.
If Parul, if you have a general query, then go ahead. As to rather, if I have to answer it that way, Parul, without answering your question directly and leaving it for you to research and find out, is look for all the provisions which give or confer jurisdiction on a particular forum. If the provisions or the preconditions for the jurisdiction upon a forum are satisfied based on the facts of your case, you can conclude that that should be the right forum. So, for example, there are two provisions which uh, deal with different courts, lay down what are the preconditions for a jurisdictional issue to be settled before that court, or give competence to deal or decide with an issue before that court. If you think that those provisions are met in the facts and circumstances of your case, you can confidently conclude that that should be the right forum for you.
Thank you, sir.
I think that is all I may answer in this regard. Yes. Any other queries?
So I received a question from a participant. They want to know how we can find
Yes, go ahead.
authorities.
Sorry?
They want to know how we can find authorities.
Okay, so as I mentioned, finding authorities, one, you can go with your, statute books, go for commentaries. Commentaries give down a lot of authorities. I'll give you an example. So commentary may have been written in 2012, right? Now, when they interpret a law which came into force in 1960, then they would have given you a thorough list of authorities as to what has happened between 1960 to 2012-13, till the time they have written the commentaries. So that is one way of understanding what commentaries may be helpful to you. The second thing is there are so many online databases like SSC Online, Manupatra, Hen Online, JSTOR, where with a simple research you will get relevant judgments which may apply to the facts of your case. And therefore, the only thing that you need to do after finding a judgment which you are thinking may be relevant is that apply it to the facts of your case. If they fit in, only then that is the relevant authority for your case. So that is how you may approach for finding authorities. Is there are databases, there are statute books, there are commentaries. Sometimes the one landmark judgment would have referred to 50 other judgments on the very same issue. So that is how you can expand your research, and you can go for a good detailed understanding of the law and finding of authorities. Yes. Any other questions? I think Shreyans, you are raising your hand. You can go ahead.
Afternoon, sir. So I want to know that the statement in mood problem should be considered as a mere statement or as a facts.
Are you talking of the statement of facts? Which statement are you talking about?
Now, statements given in mood problem.
Okay,
Is the
okay,
basic
fine. So
statement,
what you're
yeah.
saying is the contents of the mood proposition, whether they should be treated as a fact or
Yes.
or can be disputed. So as I mentioned, you need to divide your proposition into two aspects. What can be disputed or not should be figured out from your issues. Now, for example, one statement mentions that A has accused B of theft, right? But the question of law is whether B has carried out the act of theft. Then obviously that statement is not a fact, correct? But for example, there is a data given, there is a figure given, there is some other piece of information given, like for example, India is a sovereign nation, or say there are general statements like the population of the country is this much. And so those are facts, but every other thing, especially in the criminal law moot or in constitutional law moots, most of them are not facts, and you need to prove the relevancy of those facts. And if we have time, you can also go through the Indian Evidence Act and understand what fact becomes relevant fact for it to be admissible in the court of law. Not all the facts are relevant facts. So therefore, even if it's a fact, you then need to prove relevancy of that fact. And before that, you first need to prove whether it's actually a fact per se or whether it's a disputed assertion. Because if it's only an assertion, which is not a fact, that is something you need to figure out from the entire proposition itself. Because if there are contradictory sentences in the proposition, one party accepting and the other party denying a particular content or particular statement, then obviously you can't say that that's a fact, right? So that is how you need to approach a moot proposition.
Thank you, sir.
Thanks. Any other questions?
Yes, I have another question. Someone wants to know about the exact role of researchers in a moot court competition.
So I think researcher, I would say, is the karta dharta of an entire moot court team, because one, your job is exactly as the speakers until they go for the rounds, and even in the rounds, you need to continue with your research aspects, give them the latest law, help them find the authorities right away. For example, if the other team is also citing certain judgments, you need to immediately figure out what these judgments are and give chits or give information to your speakers as to how these judgments can be distinguished, so as to show that these judgments cited by the other side do not apply to the facts of the case. So I think the job of the researcher never ceases to exist. It's very, very important role to play. Some moots have researchers test as well. So there is an award for you as well. If you do really well, and if you top that test, then you also get a best researcher award. I think it's equally incentive based position. Do not undermine the importance of a researcher in the team. And I have always felt that a researcher contributes to the team in a very same way that the speakers do. Also be ready that some judges often ask questions to researchers as well. So do not take a researcher for the sake of it. Make sure that the researcher is equally well prepared. Sometimes judges have even, especially in the virtual rounds, if a speaker is facing technical difficulty in joining, then researchers are being asked to step in and take the arguments forward. So make sure that the researcher is so well prepared that, if asked to even speak and take the role of any other speaker, the researcher should be well prepared. So I think the job never ends. If I have to summarize the role, that is the way I'd put it. And apart from that, I think it would depend on the nature of the team, the requirements of the team, and also, you can always bifurcate certain role divisions within yourself so that you all are effectively participating. Yeah.
Next question is how influential are international judgments and precedents on moods?
So far as Indian moods are concerned, international law precedents, first of all, it's not a precedent. International law judgments at best will have some persuasive value, and nothing more than that. In itself, if I have to say that, international court judgments are not again binding on themselves itself, as in an ICJ judgment is not binding on a different proceeding of ICJ. So from there, you can take cue that it at best has some sense of persuasive value only if the Indian law is not contradictory to what has been held in the international judgment. Only then you may cite that. If there is a domestic law which is contrary, then the domestic law would prevail. So that is how the relationship is between the Indian law and the and the international judgments. Yes.
One of our participants joined college just 1 week ago, and she wants to know if there would be a problem as a speaker as she has not attended any classes yet.
I'm sorry, can you repeat that question? Whether it should be a problem?
As a speaker, as she has not attended any classes yet.
No, I think not at all. In fact, classes are the classes are immaterial for moot courts. I don't think you also would have learned that much in the 7 days of attending classes to even be equipped in order to go for a moot. Not at all. Rather, what I would advise is understand the law well, understand the facts that you're dealing with, be well prepared with your rational, logical arguments, and that is what would take you, into the moot. And the things like first year may whether we should do a moot or not, or whether it's the right time to do a moot or not. I think all of that inhibitions you need to keep away. And I think day zero of your law school, and with a bit of preparation, you should be ready to take up any role in a moot court competition that you wish to. I'm really it's very exciting, and I'm really happy to learn that 7 days into the law school, 15 days into the law school, students have at least given the registrations for participating in the moot court competitions. And I think that's a very, very encouraging practice, because back in my times in 2014 when I joined law school, a myth was going around that first year should not participate in moots at all. We changed that. The things have changed ever since. Moots, the number of moots have also increased. I have seen first years, second years winning moots, defeating fifth years and fourth years teams. So never get intimidated with the nature of the moot or the nature of the team. The other side may be good, but take it as a very, very good learning experience. And sometimes you can do wonders and upset a very, very experienced team as well by defeating them. So I think it's the self-confidence, the knowledge of law, and the research will give you that self-confidence that matters the most in the moot. So I'll tell you, like basically in my second, third year, when we were going moots, winning moots across the country, being from a not so very well known college back then, which is KIIT, Bhubaneswar, people were not expecting us at all even to cross prelims. When we used to face very, very good NLUs, they used to take lightly, and they were obviously, after the rounds, they used to come to us and they say, used to mention that, oh, sorry, we took you lightly, and that is something we should not have done. Because ultimately, moots are not about which college are you from. Moots are all about what research and what knowledge of law you have with you. If you can have a logical assertion, a logical submission to make, and corroborate that or cite any relevant statutory authority or any judgment to support your case, I think you will do wonders in moots. So therefore, it's not the language, it's not the vocabulary, it's not which college you come from, it's not which state you hail from, it's not your background, but what matters is the knowledge of law and research. That's all. So your confidence in moots would go leap bound if you have effective research with you. I think that is the most important asset that you should have while going forwards. Yeah. Do we have further questions?
Yes, so someone wants to know how one can present their arguments in front of the judges.
So I think I've already covered this during my general session itself, but just to repeat, I think have eye contact with the judges. judges. Make sure you have a very structured speech or following IRAC throughout, and also focus on answering the queries of the bench. Do not think that, oh, what if I don't finish my speech in time? Rather, focus on answering all the questions of the bench, because that is what you are being tested for. They would be seeing what are the kind of patience you have, the zeal you have in order to answer questions. And it's very, very important to satisfy the judges with the questions. So I think the biggest advice for your oral advocacy rounds is satisfy the bench. If they want you to answer questions, just answer that. Even if it's you are out of your time, don't make them look as if, oh, you were left out with a lot of things to speak and you could not because of shortage of time. Because as judges, we all understand that if we are asking questions, you will obviously not be able to finish all your issues that you had to cover. Therefore, what you can request for is a short extension of time, and then summarize all your issues in a very brief manner, so that it's not taken at the end that you never dealt with that issue at all. So I think that is some approach you can follow for your oral advocacy rounds. Yes.
So what is the code of conduct which one should follow in a virtual moot court competition?
So there is no code of conduct as such. Just be obviously be in your uniforms. Be thorough with your body language. Your body language matters a lot. Never laugh, never smile on whatsoever vague arguments are being put forth by the other side. Apart from that, I don't think there is any particular standard to be met. I think it's just that as lawyers, we are termed as the most ethical and noble profession. Just live up to the integrity of the profession, and that is all people would expect you out of law students as well.
So I have a question. Sometimes we get very limited time to prepare for a moot court competition, like a month. So how we can efficiently prepare in that limited time?
Yeah, I think the approach that I've mentioned is good enough for even a 10-15 day kind of a preparation. Take 2-3 days of your good time to understand the proposition. Take about 10 to 12 days for your entire research and memorial drafting, and focus the remaining 15 days of a month in order to understand the law more and more and prepare for your oral advocacy rounds. I think that is very important. That is how you can divide your timelines. That finish memorial drafting within 15 days and give 15 days of good time for oral speeches. I think that is very, very necessary as well. So that is how you can bifurcate your time if it's a month of time that is given to you.
Okay, thank you. So the next question is, what is the average number of case laws one can mention in a memorial?
So I always used to follow, and I used to always appreciate if students these days go for quality and not quantity. So I think what matters is if you are even citing 3 very good judgments on an issue, I won't appreciate if you don't know even a single judgment and citing hundreds of cases. I'd rather appreciate 3 good judgments on point on the issue, and you should know each and every fact of that issue, what issue was dealt in that judgment, etc. So that kind of knowledge would be always appreciated than just citing and quoting hundreds of judgments without really understanding what those judgments are all about. So I think go for quality and not quantity. You may go for an average 50 to 70 judgments on all the issues. I used to go for 250, 300, but I used to ensure that I read all those 250, 300 in whatever time I had. And therefore, I think that is something you can go ahead with. 50 to 70 is always a good number.
All right.
Yes.
So the next question is, someone wants to know if there are any online moot court workshops one can join to learn more about it.
So I think it's all about looking for various, opportunities, and I think you need to follow certain platforms where you have to, or you'll be getting some notifications about. I may not be able to tell you the exact platforms, but as in that's all about increasing your kind of database that you are relying on, or the websites that you are following on LinkedIn, on other platforms. I think you need to just keep your eyes open and just see and take use of any opportunity coming your way. Yeah, I think Parul wanted to see something. She had raised her hand.
Arul,
Not
you
sure.
can unmute if you have any question.
So as a defendant, can I question the facts given in the moot problem? For
Then, as I
example,
mentioned, that completely depends on the proposition. If it's a statement which can be disputed, then you are within your rights to dispute. But if it's a statement which cannot be disputed, or if it is mentioned that these are facts and cannot be disputed by parties, then it's not an option available for you to dispute.
okay, sir.
Yeah, like for example, A and B got married may not be a fact which you can dispute unless you have anything to show to the contrary that A and B have not married. Right?
For example, like if the fact says that X committed some offense against Y, so can I question? Is it
Yeah,
a
obviously, if ultimate question is whether X committed that offense or not, then yes, obviously you can dispute that.
okay, sir?
Yeah. Devanshi, do we have any other questions?
Yes,
Or
sir.
else
Someone
we
wants to
can close the
know
session?
if an entire team can be at one place and join from only one device in a virtual moot court competition.
Yeah, that's absolutely fine. And so far as you are avoiding any form of echo, I don't think that should be an issue. That's rather a better approach to follow so that you can help each other out during the rounds. But make sure the device is in such a way that it does not create any disturbance and there is no echo coming out of it. There should not be any prompting being done from behind. Nothing of that should happen. So I don't think there is any challenge to that practice.
There are no further questions. So before we wind up the session, I would like to acquaint the participants about the format of the competition. The moot court competition shall be conducted online via video conference. The competition shall comprise of 3 rounds: preliminary round, where all participating teams shall compete; semi-final round, top 4 teams shall compete; and the final round, where top 2 teams shall compete. The preliminary round and the semi-final round shall take place on 9th of November, and the final round shall take place on 10th of November. Each team will be given 15 minutes to present their arguments in the preliminary round, 20 minutes to present their arguments in the semi-final round, 30 minutes to present their argument in the final round. Extension of 2 minutes shall be allowed at the discretion of the judges, provided that the given time shall include the time for rebuttal and sur-rebuttal. There shall be a researcher test on 10th of November for the researchers, consisting of objective questions based on the moot problem. Does anybody have any doubts regarding this? Kuldeep, you can unmute and ask a question.
Hi, sorry, Devanshi, if I may take your leave I just got a meeting to attend.
Sure, sir. I will just go to the vote of thanks. I would like to extend my heartiest gratitude to Vadodara District Service Legal Authority and Organizing Committee member and founder, Ms. Hiranshi Shah of Sambhav Initiative, for making this training session possible. I would like to thank our esteemed dignitary for taking out time from his busy schedule and gracing us on this occasion with his presence. Thank you, sir, for your valuable insight. It was a very interactive session. I would also like to thank each one of you for participating in this session. I hope you have a fruitful mooting experience. Thank you, sir.
Thank you so much, Devanshi. I really had a good time. Thank you so much, everyone, for joining in good numbers and asking your questions. All the best to everyone. It's very encouraging again to see such first-year students to participate in moots. Keep doing that. Keep mooting. Even if you win or lose in these upcoming moots, do not take it to heart. Keep mooting. Take the experience forward. Go well equipped the next time again with full force and full knowledge and understanding of how a moot works. And I think just take this as a very, very good learning opportunity and go ahead. All the best to everyone. And thank you so much, Devanshi, for having me here. I once again congratulate your organization along with VDLSA for organizing this and taking this initiative. Thank you.
Thank you so much, sir.
Thank you, sir.
I request the participants to go through the brochure as everything is mentioned in detail. I have just given the gist of the competition to all of you. Now I think we can wind up the session. The participants are free to leave.
Thank you, Devanshi.
Thank you for joining.
Devanshi, you can end the meeting itself.
Okay.